Some people may think that being an education lawyer is about kind of handing out sandwiches and listening to other people talk, because that's what I'm usually doing when we're here. It in fact involves a range of different things, and so at the moment the hot topic is admissions, so I'm dealing with a lot of admissions appeals for people who, well, about the 1/3 of the population that haven't secured their preference placement at secondary school, and National Offer Day for infant school is just about to happen, and so I deal with that sort of things. Closer to our hearts with ADHD, I deal with a lot of exclusions, and so that's informal exclusions such as being sent home to cool off or being put on a reduced timetable, as well as formal exclusions and the processes around that. The Equality Act I've spoken to some of you before about. I do with lots of claims where there are issues around not only disability discrimination but also some other types of discrimination that people experience in schools. I deal with a huge amount of complaints which effectively involves being used as a stick to beat various institutions with, which I don't really mind. It's just one aspect of work. Issues around exams where people don't do quite as well as they'd expected, particularly in higher education. Where things go wrong in the independent sector, I'm often dealing with breach of contract cases where there are issues about whether the service has been provided or not, and educational negligence is another aspect of work that's really a huge growing aspect of our work, where things have gone wrong, importantly for today's topic, where there's been breaches of statutory duty, where children haven't received the care and support that they should have done, and things have gone wrong and they've suffered harm as a result of that, and there's a complicated process around it that our negligence department support with, but there are claims for damages that can arise where things have gone really wrong. I also deal with bursaries and scholarships and issues around school fees, but closest to my heart is definitely special educational needs. As anyone who knows me will know, I have been on my own journey in relation to that. So I said there was a huge irony in my becoming an education lawyer, and that's because my first personal contact with the education law system came at the age of 11, when I was first permanently excluded from school. Now, I'm not going to tell you the reason that I was excluded, but if you choose to draw any inference from the material available to you, then that's a matter for you. I should say, in case anyone's concerned about my good name with the Law Society, I've been a member for some 17 years now, that the age of criminal responsibility back then was 13 and not 10 as it is now, so there were all sorts of things you could do with your time before you reached the age of criminal responsibility. And I found all sorts of things to do. I mean, I was in the educational wilderness for about 2 years because for some reason no other school would take me. And so I met lots of other good, fun, exciting people who were not in education or training, and were finding stuff to do with their time, and I learned all sorts of transferable skills that I could then use in later life as a criminal litigator. I was allowed back into school at the age of 13. They allowed me into a mainstream school in Hammersmith and Fulham, I won't name it, but I had kind of become quite disaffected by then, and whatever the problems were that I had when I was 11, I still had them when I was 13 because I hadn't had any kind of intervention. I'd also had no education during that time. So I lasted at that second school for about 8 weeks before they decided that I should be permanently excluded from there as well, and I won't tell you what that was for because I was old enough then. I then went back to the educational wilderness where, because I was a little bit older, I kind of met with people that were slightly more sinister and advanced, more sophisticated than I was, and we got up to all sorts of things. Around the age of 15, there was some social services involvement, and they decided that I needed to go to something that's a sort of, nowadays it would be like a cross between a pupil referral unit and a young offenders institute. So it was a secure assessment centre that I went to, and it was secure in the sense that, not that it was cosy, but there were quite a lot of doors to get through. I did manage to escape though, and so I did what all self-respecting young girls did in the neighbourhood that I grew up in anyway, and got myself pregnant. So I became a teenage mum, and at the age of 16. And it was against that backdrop that I went on to get a first-class degree in law and qualify as a solicitor, roughly at the same age of my peers, who had almost all had better backgrounds than I had in terms of education and in terms of the sort of support that they'd received generally. And that was a challenge, you know, it wasn't easy, but it was absolutely nothing compared to the challenge that I would face when Damien, my youngest son, entered the education system. Now, Damien is not his real name. It's a term of endearment that we use for him in our family. And it's also a subtle warning to teachers that are going to come into contact with him what they might have in store. Now, Damien is an unusual enigma for the education system because he's a member of Mensa. He has an IQ of 151. He's a very talented footballer and athlete. But unfortunately, when he entered the education system, and probably for the first few years he was there, maybe around the age of 6 and 7, he had the emotional and social skills of the average toddler. And the reason for that was because he had ADHD, some autistic traits, and some sensory integration issues, which meant that the education system really didn't work well for him. So I brought this perfectly nice, seemed nice enough to me anyway, nice, bouncy, talented boy into the education system. And what happened was this. They told him that he was bad and also stupid because he couldn't really write, although he was quite clever. They told him that he was lazy, and he knew by the end of the first year or so of being there that he must be quite dumb, because everybody was kind of having quite a negative reaction to him. Some of the reactions were quite extreme, and bearing in mind that I live in Richmond and most of the parents are quite nice and middle class in Richmond, you might be quite surprised at some of the things that happened. So I had parents going up to what we'll call our Damien in the playground and grabbing him and shouting at him because he'd done something to their children, and I'm sure whatever he'd done was quite horrible. You know, I don't doubt for one moment that whatever he did was probably inappropriate, but he was 6 at the time. I had a couple of dads come up to me and give me a good shouting at to, you know, let me know that I ought to be keeping that child of mine under control, because clearly the assumption was that I sent him off to school in the morning saying, you know, make sure you punch someone in the face, don't forget to swear at the teachers. That's not what I did, but it seems to be what they thought. And after a while of, you know, trying those methods, they thought they'd get together and have a meeting. So they got together, had a meeting, and decided to start a petition. So they weren't happy that the head teacher was allowing my son to stay in school, and so they did a petition to the education department to say, we don't want our children to be educated with that child. Well, he soon enough, you know, got that message, and, you know, it was a pretty miserable time, and so I kind of felt a little bit like that. So I made my sort of first cry for help, I'll call it. So I spoke to school, because school are the experts. They must have dealt with this kind of thing before and, you know, knew what they were doing. So what they did is they said, yeah, school's really too much for him, so we'll put him on a reduced timetable. He can come to school till 12 o'clock. Because that will be very helpful to him, and I'm sure it had nothing to do with the fact that it was a lot more helpful to them. They said he can go on school trips, but he can only go on school trips if you come with him. And he can't go swimming anymore because he won't keep the seatbelt on and sit still when we're on the coach. So that was the adjustment that they made. And I said, well, isn't there anything else we can do? Because, you know, this is my 3rd child, and, you know, he's really quite different. And they said, yeah, we'll get in our educational psychologist. So the local educational psychologist, who happens to be a trainee who's just stopped working in this borough, but was working in this borough until very recently, came in, had a chat with the teachers, found out how clever he was, observed him in class for about 5 minutes, and said, there's nothing wrong with this child. He's got an anger management problem, and the reason he's probably got an anger management problem is because you're a single parent, and he's probably watched some kind of Discord at some point, and he's just acting it out. So he's got an anger management problem, and what he needs to address that problem is to go through an anger management book, nice little booklet with a TA in school who's not trained in special needs, who's not an anger management psychotherapist, but if he works through that book, things will get much better. So I said, yeah, but what about the other things? What about the fact that he's really clever but he can't write? What about the fact that he can't actually sit still? What about those things? So they got on the local authority OT, and the local authority OT didn't notice any sensory processing issues, didn't notice that he couldn't sit still, but noticed that he couldn't do handwriting, and so gave him some finger wiggling exercises to do to warm up his hands before he started writing, which was very helpful. Not. So then, and this was quite impressive at that time, I suppose, after I begged quite a lot and sort of cried to the head teacher, they got in a behavioural consultant, and the behavioural consultant came in and she was brilliant, and she noticed lots of things, and she said, I think there are some underlying issues here. Looks a little bit neurodevelopmental, might be autism, might be ADHD, looks like we need some follow-up here. And everybody sitting in that room, there were about 9 professionals in the room at the time, said, think you're barking up the wrong tree. There's nothing wrong with this child, he's very clever, there are some issues in the background with the family, and that's not what's needed here. So they dismissed that, but eventually, after some time, I spoke to the school nurse because he also had other issues, like he was wetting himself quite a bit and at night and things like that, and he couldn't really sleep. And so in the end, the school nurse referred to CAMS, and at last I thought we're going to get some help. What Cam said was, you haven't finished working through the anger management booklet yet with the TA. Things aren't really bad enough, so we're not going to accept this referral. And so a couple of days after that, that letter coming back, our Damien, as we'll call him, was rocking on his chair in class, because of course he couldn't sit still. And so he got into trouble with the teacher. When the teacher told him off for rocking on the chair, he told her to F off, because for some reason children with ADHD learn swear words really early. I don't quite know why that is. But anyway, he told her to F off, so he was told, okay, you're going to miss 5 minutes of your playtime. He didn't want to miss 5 minutes of his playtime, so when they locked him in the room and said, you will sit there and you will stay in, he said, no I won't, I'll knock all the chairs over, I'll knock the bookshelf down, I'll swear at all of you and I'll have a right old fit, which is what he did. And so they suggested that he possibly wasn't safe to be on school premises and that he might go to a pupil referral unit instead. And I said, I've been to pupil referral units, I know what that means. He doesn't need to learn how to smoke at the age of 6 or to play pool, so he's not going to go there. So I had a great idea. As all parents who've got money or any access to any money, I'm going to send him to independent school, because what he actually needs is a school that will do lots of sport with him. He's really competitive. Maybe he needs to be somewhere that's more competitive, where they've got old-fashioned discipline, because remember, there was nothing wrong with this child according to the professionals, so what he must need is a change of environment. So I sent him off to an independent school, and who couldn't do well wearing short trousers and socks with velvet at the top? But anyway, sent him off to an independent school, and within about 2 weeks of him being there, they said, there's something wrong with your child. And so he entered like a bull in a china shop. And at that stage, I managed to contact the behavioural consultant who suggested there might be something wrong, spoke to a private educational psychologist who met with him and said, yep, he is superior range bright, but he couldn't sit still during our assessment. He was actually climbing all over the table and jiggling all over the place. I suspect that he has ADHD. I can't diagnose it because I'm a psychologist, so I'll refer you over to a big, well-known hospital in Roehampton where you can get a private diagnosis, because if you wait for CAMS, you'll be waiting for the rest of your life. And it went really, really well, and I have to say that without taking one tablet, I was immediately hooked on Concerta, because it worked like magic for my particular son, and for 18 months we lived in this Ritalin bliss, where I would give him a tablet in the morning, which was contrary to everything that I'd ever thought. I mean, I've got 3 children, certainly by the time I was parenting the boys, they were raised on, organic blended food. So giving drugs to my child was not my idea of a good plan, until the point that I was so desperate that if they'd said give him crack cocaine, I would have given him crack cocaine, because quite frankly, I just needed that school placement not to fail, because it felt like that was the most important thing in the world, and you know, being in school was really the most important thing in the world, which was so ironic considering I really didn't have much of an education. But anyway, it seemed like it at the time. It went really, really well. But what I didn't know, and what the psychiatrist that I was paying like £400 a visit to go and see didn't tell me, was that over time you need to adjust medication because it loses its effectiveness, because your child grows, because their organs start metabolising differently and things change. The other thing that happens is that the demands of the education system change, and if you're in private school it happens a little bit earlier. So at quite a young age, I think he was about 8 by then, they start going to moving around to different classes for different lessons. They start being expected to have things that they need and really use all those executive functions that children with ADHD don't have. So he started year 5. What is year 5 in the state system? Started in September, and by November, unfortunately, he was expelled because his medication wasn't working, because the demands were just too great and he couldn't cope. And he basically kicked and punched a lot of people. He couldn't cope with losing in sport mainly, so he did a lot of kicking and punching of people in sport. And when he was pulled up by the deputy headmaster about his behaviour, he gave him some choice language and said he didn't care what an old man like him had to say anyway. And so I got a phone call. I was here actually, I was working here at the time. I got a phone call saying, you know, we've had enough, can you come and pick up your son? And it was awful. It was really awful because I realised that it hadn't been a sort of accepting school that tolerated my son. They just tolerated him as long as he behaved like everyone else, which he could do with very effective medication working, but he couldn't do once that wasn't the case anymore. And you know, I'm a huge believer in the social model of disability, because actually he was, you know, his behaviour, not the most extremes necessarily, but the things that happened before the extremes, is just very normal for a child with ADHD or autism. And it's just that the system is not designed to meet the needs of different types of children. It's just designed to meet a sort of very main, average, narrow, you know, sort of quite narrow band of children. And so I was left kind of feeling like this again, and so I was kind of catastrophising, and in my mind he was going to end up in Felton Young Offenders Institute. You know, I was absolutely sure he was going to prison. I was a criminal lawyer at that point in time, and I knew what happened to children like him. You know, I knew where I had almost got to as a child, and you know, it was really, really miserable. I was having a really difficult time. My son was out of education, which meant that I couldn't work. I couldn't work because I was looking after him. I couldn't get paid because, unfortunately, people don't care if you've got a kid that's out of school because they've been excluded. They don't pay you to sit at home. And so it was really damaging to me professionally. It was a really difficult time. He wasn't provided with any education. As it happened, as he was in year 5, I just got him to do 11 plus papers at home, but it was a really miserable time, and he felt like that because he couldn't understand. He knew by this time that he had ADHD, and he thought, well, if I know I've got ADHD and this is why things happen, you know, why wasn't I allowed to stay at school? Because I actually really liked that school because I was in the, you know, A team for football. So he really couldn't understand it, and of course lost all his friends. It was absolutely humiliating for me because I have an older son who's just a year above, and he was still at the same school. So despite the fact that that school did a deal with me and said, as long as you don't bring a disability discrimination claim against us, your son can have a scholarship and will have the best reference ever written for when he goes to senior school. And I accepted that deal, I should point out. But anyway, despite that, I had to go. And it's really embarrassing because all the parents stopped talking to me and would just kind of ignore me when I came in, which was a really horrible thing. And my older son actually, and I think this happens to siblings a lot, he started being slightly ostracised as well. So despite the very good financial deal for him, we didn't stay there for very long. But sometimes when the worst of things happen, and when the thing that you're really thinking is like, oh my God, this would be the worst awful thing in the world, which for me was another permanent exclusion, when it happens, sometimes actually it's a really good thing. It's just that you just don't know it's a good thing at the time, and it doesn't feel like it. And so the first good thing that happened was my kind of knight in shining armour. About 3 o'clock in the morning, while I was probably like crying, might have been smoking, and definitely was drinking a lot of coffee. I came across IPSY's website. So I don't know if you're familiar with IPSY, but IPSY's a national charity that helps parents of children with special educational needs. It has the most amazing resources online that you can use. It also has a helpline, and it also has tribunal representatives who can actually help people case manage and then represent in tribunal cases. And there's a link to IPSY on the ADHD website, so you don't need to write it down. But I soon realised that this was really, really important information that I needed to have. So to cut a long story short, I did their training, I did other legal training elsewhere, and became a tribunal representative volunteer. People are like, are you crazy? Like, you've got all this stuff going on in your sad, failed life. Like, why are you spending your time doing that? But I said, well, I'm doing it because, one, I believe in what I'm doing, which makes a change, having been a criminal lawyer. So I believe in what I'm doing, but also I'm upskilling myself because I realise that this is not an easy fight. And so that's why I'm doing that. And so my next cry for help was to the local authority, because I realised there was this process that I could get a statement of special educational needs potentially, and I went to them, and despite the fact that they kind of looked like that they've got too much work and everything else, I had a surprisingly easy time at this point. And it was a bit like, oh, there's like a silver lining to this cloud, because they immediately agreed to assess him. They hadn't provided him with any education while he wasn't in school, but they immediately agreed to assess him, and they agreed to give him a SEND statement. Now, I know that that's not necessarily most people's experience, but that was mine, and it went quite well. The other thing I came across during this bleak period was Richmond ADHD, which was definitely felt like, at the time, a huge relief, because it's quite easy to become very sort of socially isolated when you're going through this process, and so it was so nice to have a bit of solidarity and hear from that you weren't the only one whose kid got excluded from school all the time and did horrible things, and that you were really struggling with this system. So those things went really well. I put eventually our Damien in a local Catholic school. It was just the only school that had a space. There was no choosing. This was before he had a statement. There was no good choosing about it, and I just got lucky, because this is not everyone's experience of this type of school. But by the time he went there, he was soon to be in year 6, and the year 6 teacher was brilliant. And this is really the experience of a lot of people with ADHD. You get like one good teacher and you have a great year. You get an awful teacher who doesn't understand and the world falls apart. And this teacher, Mrs. Mail, was fantastic. She didn't know about ADHD when we arrived, but she read everything. She did training. She gave me her mobile number so that she could contact me and I could contact her, especially when my son needed talking down because he was about to run out of the school or do something crazy. She met with me all the time and spoke to me. She took sessions with the whole class, actually, and people have mixed views about this, but I found that it was really helpful. She took sessions with the whole class explaining this is what ADHD is, this is some of the things that it makes difficult, these are some of the strengths that you can have when you've got ADHD, and with my son's permission, she explained that this is why sometimes this boy in your class behaves a little bit differently, and importantly said, and what do we do with children who have got differences? So if somebody is in a wheelchair, do we open the door, do we give them a hand where it's needed? If somebody's got other types of differences, then we also help them. And part of that actually, and I'm not religious, I should say, I think was because the ethos of the school was actually quite caring. And so, ironically, out of that session, another child went home and said to their parent, I think I've got ADHD, and we're a few years later now has a diagnosis. So it's a really important thing that teacher did. But the two most important things that she did was she became our ally against other members of staff. So other members of staff that weren't that enlightened, she would stand up and argue his corner against them. And tell me about it, which was also quite good. But she also believed that this was a child with potential, and that was really important. So she didn't forget that he was a child who was supposed to be being educated, who needed to learn. She said, yes, we've got to deal with the behaviour, but we've also got to remember that this is a child who needs to reach their academic potential. my love affair with the local authority didn't last for very long. So whilst I thought, look, I'm so clever because I talk to them really nicely and I write really good letters and they just listen to me as a parent, it kind of went really wrong because we then came to secondary transfer. And I was like, right, so you know this child's a member of Mensa because he went and sat the test at 10 years old all by himself with a load of adults. We know he's really clever, so surely he should go to the local school for clever children. But the local school for clever children didn't really feel the same about him. And they kind of said, we've read that statement and it says that he's disruptive, it says that he's abusive, it says that he can be violent, and that will prejudice the efficient education of our nice children. And I was saying things like, hold on a minute, they're really clever children, exceptionally clever children at school. Surely it should be easier for them to learn if they've got a bit of noise going on in the background, easier than for the school down the road that you're suggesting he should go to. And the local authority said, we don't really care what the law says about your right to request placements. We're not going to fall out with our local schools in our boroughs. And so your son can't go there. He can go to the school down the road because the school down the road deals really well with special educational needs. So, well, I'm not sending him to school to deal with his special educational needs. I'm sending him to school for an education because I want him to learn and reach his academic potential. You seem to be missing the point that this child has, more than one aspect to him. And they said, well, we don't really care what you've got to say, so you can get lost. So I said, okay, fine. Well, I've just spent the last couple of years now training and upskilling myself, and as is the case for a number of people, I know a number of people in this room, what happened was I had all the stress of preparing the appeal. I had, and I'm a lawyer, and it was still incredibly stressful. One, because it was personal, but two, because it's just really hard. I mean, it's really hard work because you're trying to have this battle, but you're also trying to manage the needs of your complicated child, and sometimes other children as well. But sometimes you're trying to have a job as well, maybe even a life, and it's really, really tough going. And so I took them to the tribunal, and I worked really hard, and I had loads of stress and had anxiety. And he had anxiety because all the other children knew in March at National Offer Day which school they were going to, but my son didn't because it was still all hanging up in the air. But to cut a long story short, I don't like losing, and so I won. They settled in the end, and the independent selective school that I wanted him to go to was named with a large amount of funding for support, because although he didn't need academic support in terms of his basic learning, he certainly needed support to navigate the environment in which the curriculum was delivered. So to protect other children and himself, that support was put in place. So far, I have to be honest, it's not been all plain sailing. I got what I wanted, but I think in the first year of being in secondary school, and everyone knows that the first year of secondary school is the hardest transition for most children with neurodevelopmental conditions. I think he now holds the all-time record for having the most attentions ever got in that particular school, for getting them earliest and first and most and the worst ones. I spent a lot of time speaking to the deputy head in the first year. We had some dialogue that worked really well, I have to say, between the school, the local authority. By this time, I was being an education lawyer, and so I was kind of talking softly but carrying a huge big stick, and I think that helps. But the CAMS got involved as well, and I have to say, I'll say it so he can hear me, that that Dr. Newman was absolutely fantastic in that process and gave help where it was needed to inform the process to make sure that reasonable adjustments were being made. But the main thing is that the school's learning support system, because it's a private school, is not completely under-resourced. They're actually really, really good. They actually do a really fantastic job there. So we got to the end of the second year with no phone calls home, no emails, no conduct detentions. I think there have been a few work detentions, but a really good year. And I mean, I won't bore you to death, reading it all, but just to give you some examples, this is an extract from the report just before Easter. Great focus, great effort, completes all his work. obviously he doesn't get any help with his homework, he still doesn't do as much homework as he should, but he's moving in the right direction, and this was the answer to questions that were being asked. And the bottom one was about how's his behaviour, how is he socially, and it says very positive, knows the boundaries and rules and is quick to settle. Now, that couldn't be more different from the experience of the 6-year-old and 9-year-old, but eventually with maturity and with a lot of intervention. So he's had intensive anger management psychotherapy from a qualified therapist and all sorts of other interventions put in place. But so it shows that there is some hope. I'm ever vigilant. I'm not at the end of the road with this particular child. He's my third one. I feel like when I get to the end of the road with him, I can just retire from life, really. But we know we've got Year 9 hormones to come. We've got the transition to an education, health and care plan, which I know people are having all sorts of interesting issues with. And I've now got some hope. So I'm now no longer worrying and focusing on, Feltham Young Offenders Institute, and I'm starting to think again that this able child might go into further and higher education, although that's not his plan, because his plan is to be the manager of Nando's. But right at the beginning, there was a failure to identify special educational needs. Now, I'm not going to read every definition through, but I've got these here so that people can use them and look at them later. But definitely, my son had a disability which prevented or hindered him from making use of the facilities generally provided at school. Most children with ADHD, and bearing in mind many children with ADHD also have autism, sensory processing or other issues, anxiety, and other issues going on, most of them will have difficulty accessing the environment. Many of them will also have difficulties with the actual process of learning because of attention problems and other issues that go with having impaired executive functions. So it's my view that almost every child with ADHD has special educational needs, and those needs should be identified. So with this story, that didn't happen. And so for every child that has special educational needs that doesn't have a statement of special needs or a plan, which for anyone who doesn't know is a separate pot of funding in addition to what the school normally has. In these days, and I should point out that when I was dealing with my son's issues, we were under the old law system. This is the new law system, but it's easier just to talk about that. Any child like that should be on SEND support. If they're on SEND support, the school should be they've got a legal duty to use their best endeavours to secure special educational provision for that child. What that means is they should be providing therapeutic intervention if that's needed. They should be providing extra support in terms of adult support or specialist teaching if that's needed. I have a child that you couldn't not notice in a classroom because he was so loud and difficult. There are many children in the class who aren't loud and difficult, and they're just being ignored because they're quiet and inattentive and they're looking out of the window. And it's really important that those children who are more likely to be on SEND support because they're not causing a big fuss are noticed and that their needs are identified. And I've talked before to this group about the system now is assess, plan, do, review. There is a code of practice that schools have to follow. They have to have regard to it and only not follow it if there's a good reason why not to. And they should be assessing that child's needs and then making a plan about what should be happening. They should be then carrying out that plan and that therapy or that extra support and then reviewing it at regular intervals to see whether it's working or not. And I think there was some discussion about that in our last session. All staff should be aware of this, and it's not limited to learning. So there's a big misunderstanding and myth perpetuated that this is just about learning. And so if a child is broadly in the average range, which is really easy to be in because the average range is like 25th percentile up to the 75th percentile, so you have to be extremely bright or really, really struggling to not fall within average range. So even if a child is in average range, they may be having social, emotional and mental health difficulties, they may have sensory and physical difficulties, so it's not just about cognition and learning. They may be struggling to understand the social world, they may not be making friends, or they may be making friends, but if they're anything like me, they're making exciting friends that you do bad stuff with. They're not going to be hanging out with the nerds, as I'll badly call them. But the most important thing really here about the story and what went wrong, though, is that if you've got a child that you're basically struggling with, they're just not learning or they're just really difficult to manage, and you can't meet that child's needs, so you're a school and you don't seem to be able to get it right with this child, or if you don't have the expertise or the funding, as the very well-meaning staff at my son's first school, they just didn't really know what they were dealing with. It wasn't that they were horrible. I mean, they were really nice to me. They used to invite me in. They used to be really pleasant and sweet and everything. Obviously, until they were kicking him out. But they were really, really nice in the beginning. But they just didn't know what they were dealing with. So if you're a school and you come across a child that you just don't know what's going on with them, then the right thing to be doing is to be thinking, what's my next step? So if you know what's wrong with the child, you think, look, this is definitely ADHD or definitely autism, but you don't have the funding to provide all the extra support they need. Those are all of those things are the circumstances where you should be triggering an education, health and care needs assessment. And so if a school has a child like the child in our story of today, my son, that they can't cope with and they really don't know what to do, they should be saying, let's go to the local authority, and it's the school that should be doing that. But parents can do it too, and anyone who speaks to me because they're having issues will know that I'll say just do it yourself, because ultimately when things don't work out, it's your right of appeal, so you should do it yourself. But this is what schools should be doing. They shouldn't just be going, oh, I'm going to phone up that parent again and tell her that her child isn't learning or her child is not behaving or whatever. That's just not that's not good enough. So just so that everybody's clear, and I know that there are some people in this room who've been told all sorts of untruths about this test, and I've given it to the group before, but the test for when an education, health and care plan assessment should be carried out is when the child has or may have special educational needs, which is everybody who's got a diagnosis of ADHD or everyone who looks like they might need a diagnosis of ADHD, and that it may be necessary for special educational provision to be made for that child. And what that means is that a plan or a statement might be necessary. So not that it definitely is. So what the local authority will do is they'll decide whether they think you need a plan or not, according to their own policy. But that's not the test. The test is we're just looking about assessing this child's needs so we understand them better. Because we might not understand exactly what's going on with this child. We might just be seeing the behaviour, and that behaviour might be the tip of the iceberg, or we might just notice that this child is not making the expected progress that they should be making. But we don't know why that is. So that's the test for when an assessment should be carried out. The threshold for when they ought to issue a plan is that it's necessary to issue a plan. Now there's been recent case law on this, and I won't bore you with loads of law, but basically what that necessity test is regardless of what should be happening in schools, regardless of what should be happening in your local school, even if your local school is rubbish and doesn't do special needs very well, if for your child to get the provision that they need, a plan is necessary because the school is just not doing what it should be doing, then a plan is necessary. So it's a necessity test, and that's all it means. And so it's in fact, in my opinion, a lower threshold than most people think, because they think you have to really be struggling, or the school have to have done everything that they possibly can, or you have to have loads of reports from educational psychologists. Actually, that's not the test. So local authorities have their own policies. Policies are not the law, they're just local practices and the way that they like to do things. So if you don't have an education, health and care plan, but you're in one of those circumstances where needs are not being met, then it's certainly worth applying for an assessment. The other thing that you saw in my story, I mentioned to you that school decided that my son should only attend school till 12 o'clock. There was no exclusion. I didn't ever get a letter saying your child's been permanently excluded from school after 12 o'clock every day. They just decided that it would be a good idea, basically because he was driving everyone nuts, and they thought it was a good idea. I mean, it was a brilliant idea for me not, because I was trying to have a job, so I had to go and collect him at 12 o'clock. I didn't know at that stage, so thinking back to when he was 6, I didn't know that was unlawful. I didn't know that you're not allowed to just send pupils home that are really annoying. And it's really important because what the law says is that a pupil's entitled to be admitted to school irrespective of his disability, and that should not be on terms less favourable than anyone else. So if everyone else is allowed to go to school till 3:30 or 3:15, then so should this child. If everyone else is allowed to go to swimming lessons, then this child should be allowed to as well.
Does that apply to sixth form as well?
Yes. Yeah. And so there's, but the most important thing, and this comes from the exclusion guidance, that's statutory guidance for schools, is that it's unlawful to exclude or increase the severity of an exclusion for a non-disciplinary reason. For example, it would be unlawful to exclude a pupil because they have additional needs or a disability that the school feels that it's unable to meet. So if a child is just hard work or just causing a lot of difficulty, then the lawful response to that is not exclusion. Okay, it's not to send them home to cool off because it would just make everyone's life easier if they went away for a couple of days. It's not to say, oh well, they shouldn't come back even though the fixed term exclusion we've given them has ended. None of that is okay. That's all unlawful exclusions. Yeah.
That doesn't apply to internal exclusions as well, does it?
Well, internal exclusions is a different thing, so they're not unlawful as in the unlawfulness around this is that a child has a statutory right and a human right to have an education, and the school and the local authority are under various obligations to provide that depending on the circumstances. An internal exclusion is not depriving them from being in school, but it might be less favourable or unfavourable treatment. So any kind of punishment or sanction is unfavourable treatment. No one wants to be sent to the cooler or the bin or whatever they call it in these schools at the moment. A lot of it happens. So a lot of the policy at the moment, particularly in academies I've noticed that are trying to improve behaviour, is that any time a child's naughty without even, and naughty is probably not a word you're supposed to use, but anyway, when they exhibit challenging behaviour, then they're just sent straight away out. So as not to disrupt teaching time. Often they haven't had an opportunity to even give their side of the story or anything. They're sent to this kind of internal exclusion. That's unfavourable treatment, and it's less favourable treatment than than other children might be given. I'll come to it in a minute, but it's one of the types of disability discrimination if the thing that they're being sent out about is related to their disability. So to give you a really quick example, if I have ADHD, as I happen to actually have, I should add, if I have ADHD, I'm impulsive, so I might call out quite a lot in class because if a thought comes into my head, it's come out of my mouth before I've even remembered to just stop and pause. And so if I'm sent constantly to internal exclusion because I keep calling out in class and I have a diagnosis of ADHD, then that's discrimination because it's unfavourable treatment arising because of something connected with my disability. Now, the school may have defences to it because they might argue, well, we've got a legitimate aim here of keeping good order in class and everybody learning, but it has to be proportionate, and they also have to have made reasonable adjustments for those underlying problems that this child has. So if nobody's put in place any suitable intervention to address that issue of impulsivity in the classroom, and there are various things that you can do, then it's likely to be disability discrimination. So it's likely to fall under a different heading rather than unlawful exclusions. So then there are formal exclusions, and again, I'm not going to read through everything here, but it's really important when there is a formal exclusion, so that's a fixed term exclusion, for 1 day or 5 days or whatever, or a permanent exclusion, there is a procedure to follow. So there is law and guidance around that schools have to follow. So they have to be lawful, reasonable and fair. Well, that's something that you might hope that your head teacher would be, but they're not allowed to discriminate. They're not allowed to discriminate in terms of the way in which they carry out sanctions, and that's really important. And they have to remember that disruptive behaviour can be an indication of unmet needs. Where a child may have ADHD, it's highly likely that there are some unmet needs and that there's something going on there, and they're expressing by actions what they're less able to express with words. And this is a really important aspect, that when you're considering excluding a child, particularly permanently excluding a child, then you have to make sure that you've explored all other options. So is there some extra SEND support that should be put in place? Do we need to get some external training and advice on how to manage the needs of this child? Could we maybe do a change of class? Could we rearrange things a bit? And exclusion, as the guidance stands at the moment, must be a last resort. And this is just a bit of an aside, but I think it was January 2015, the government brought in some new guidance, and the new guidance had removed the exclusion as a last resort, so it made it easier for schools to exclude children. This, I think, is part of the whole kind of academies, let teachers do what they want and let them improve behaviour and make it easier to exclude difficult pupils. The government was challenged on that guidance, largely because of boring stuff to do with consultation. So that guidance suddenly disappeared and was withdrawn. So we're back to what I think is the much better guidance that says, it's got to be a last resort. But it's likely that things will change given the sort of general spirit of how things are going at the moment. But of course, with formal exclusion, you are sometimes falling foul of the Equality Act. So even though you might have followed the general exclusions guidance and followed the right procedures, a child may have a disability, highly likely in most of the case law where there's been a child that's been excluded because of ADHD related issues, then the judges have accepted that this is a child that's disabled. You're disabled, and this is not a political or a philosophical view about ADHD. My personal view is that people with ADHD are just wired differently, but because society is so disabling and there are so many barriers to being different, it's useful to think of your children as being disabled when you're trying to either stop something being done or get something done. So even if you want to tell them there's nothing wrong with you, you're just wired differently, which I get and I understand, for the purposes of dealing with professionals, it's useful to remind them that you're dealing with a disabled child. It's a hidden disability, you might not be able to see it, but they're disabled if they've got a physical or mental impairment that has a substantial and long term. That means it's been going on or likely to go on for more than 12 months. Adverse effect on their normal day-to-day activities. So if they struggle to go to school, they struggle to be at home, they struggle to brush their teeth, anything that you do on a normal day-to-day basis, if you've got an impairment that prevents you being able to do that or impairs your ability to do that, then you have a disability in law. And if you have a disability in law, you're entitled to protection of the Act. In the case that I explained to you the story of my son, certainly there were a number of schools that fell foul of the Equality Act because they treated my son unfavourably by excluding him, by not letting him go on trips, by putting him on a reduced timetable, because he wasn't able to control his impulses, and that was definitely something that was related to his disability, and arguably they couldn't show that it was a proportionate means of achieving a legitimate aim because they weren't trying to do anything else first. There was a failure to make reasonable adjustments, and what that means is to make the situation easier for your child to meet the expectations of that environment. So you're allowed to treat them more favourably, you're allowed to treat them less harshly in terms of sanctions, and just generally differently. And schools are under an obligation to make reasonable adjustments. There is no fixed definition of what a reasonable adjustment is, but what it means is that you need to think about ways that you can make life easier for the child concerned, whether that's providing them with extra equipment, whether that's providing them with a person to support them, whether that's saying, okay, we're not going to punish you when you call out in class, we're going to try and teach you some methods of dealing with things in a different way. All of those might be reasonable adjustments, and it depends slightly on the circumstances. Yeah.
Does that go for sixth form
Yep.
as well? Because that's a problem, because a lot of these sixth form in schools are very separate and haven't
Yeah.
really got any.
Yeah, so a sixth
support.
form is still a school, if it's in a school, and if it's not, it's a college. And all sixth forms and schools, and businesses and other things, but under slightly different bits of law, have to abide by the Equality Act. So when you hear things, about, having to put ramps into new restaurants, for example, that's an adjustment that's being made to foresee the needs of all of the different users. And in schools, the position is exactly the same. So if you're in sixth form, if you're in university, so a lot of, I don't know how it happens,
but seem to be running differently to the
yeah.
school though with the support.
Yeah. So now further education colleges are covered under the same legislation. So further education colleges can now be named in statements as placements as well. So in statements or now education, health and care plans. So the law is changing. Locally, further education colleges may not have noticed that the law has changed and the obligations are different, and maybe that will take time, but it's very useful for you to be aware of the Equality Act. You don't need to know it, but it's useful to be aware that when something could make life a lot easier, like for example, a really classic example is that chewing gum is not allowed in school because, how dangerous to chew gum. And if you have difficulties with your motor skills and you're fidgety and everything else, yeah, you can get like a fidget toy, but it's a bit difficult to write when you're using a fidget toy. So if you can chew gum, then that gives an outlet for your need to move. That would be a reasonable adjustment. If you have sensory processing issues and you can't deal with texture, being able to maybe not wear a tie or to wear a slightly different uniform would be a reasonable adjustment. So little things, so they're often not costly, huge things that can make life easier. But it's really important to be aware of those things, and also to be aware that if you're at independent school, because a lot of the law doesn't apply to independent schools that we talk about in the SEN world, but the Equality Act does. So in fact, the greater number of Equality Act claims that I've been involved in are against independent schools, because basically it's all you've got. And if you're dealing with a disabled child, then it makes sense to use it, but also because sometimes they can be slightly behind in terms of understanding because they're not subject to the same codes of practice. So the other thing that I alluded to in the story of my son was about education. So when he was excluded, he was just at home. So it's just like, here's your child, you deal with him because no one else can cope. And actually the local authority are under an obligation to provide full-time suitable education for children who are permanently excluded, who can't attend for medical reasons, or for any other reason. So basically, if your child is not in school, and the only caveat to this is if they have offered your child a place at a perfectly suitable school and you're not taking it, then that doesn't mean they need to provide home tuition for your child. But if your child cannot be in school for a variety of reasons, but often it's exclusion, or because a placement has just completely broken down, then they're under an obligation to provide education. Now what they'll say, and some people in this room know this really well, is they'll say, well, there's no definition of full-time education in law. Well, actually that's not quite right. There is no actual definition of what is full-time, but there's plenty of guidance, statutory guidance around that says it needs to be the equivalent amount of education to what they would be having if they're in a mainstream school. So an ordinary infant's day or an ordinary secondary school pupil's day, and that's got to be provided, and it's got to be provided at their own expense. They think what the law says is 1 or 2 hours a day at the local youth centre for some reason, but that's not what it actually says, and there are obvious reasons why they'll interpret the law in that way, and it's because they're all trying to protect their budgets, is the term that they use. They're all trying to protect their budgets for understandable reasons, but that's just of no assistance whatsoever to you when you're trying to get an education for your child when they're not in school. And the quality of that education as well is quite important, so it needs to be sufficient to enable good academic, personal and social attainment. So i.e., going along to a youth centre and just hanging around, not doing anything or doing kind of extracurricular activities is not suitable education. And it's really important to be aware of that. Because there are people, they're either called inclusion or exclusion officers in the local authority, whose job it is to sort of bat you away, it would appear, when you come along and say, I'd like some education for my child that's not in school. I have to admit that when my son was out of education, I just didn't even know that there was an obligation, so I didn't try and get any education for him. So